Damn, that's fabulous.
Alrighty, guys. I know I said I was going to weigh in on this topic again. If you've been keeping up with the Derek Chauvin murder trial, both the prosecution and the defense have now rested their case, and we are going into closing arguments coming Monday. And the reason for this is because after closing arguments, the jury has to be sequestered or separated from the rest of society until they deliver a verdict. So it looks like Judge Hill didn't want to keep them over the weekend, so he moved closing arguments over to Monday. Now, we have a lot to break down and what has happened since my last video. Let's talk about the defense case a little bit. The witnesses that the defense chose were pretty bad, and I actually think that they did not help Chauvin's case at all. Particularly the use of force trainer and expert Barry Vance Broad. Barry Vance Broad is a gentleman who owns a use of force consulting company used to review police conduct around the country. I believe he stated in direct examination that he's paid $250 an hour to analyze use of force cases. So right off the bat, that's problematic because this guy is basically saying he's a paid expert witness. He gets paid to testify in court. So that kind of shows that he does have a horse in this race, or he's on a particular side. But that wasn't even the worst of it. So what really made him lose credibility is when the state was asking him if, being pinned down with your face on the floor could produce pain. And he said it could, or, we don't know. So right off the bat, that showed that, he, didn't want to play into their frame. Then he wasn't even admitting to the knee being on the neck. He was saying it was on the upper back, and the prosecution had to pull up a screen, have him circle the knee, have him circle the neck before he finally agreed the knee was in fact placed on the neck. So that witness was really problematic. The next witness that they called, Dr. Fowler, was pretty bad too, because he tried making the case that Mr. Floyd died of carbon monoxide poisoning, or could have died from carbon monoxide poisoning from the exhaust from the police car that they were next to. Now, I think it goes without saying that that's a pretty weak case. Yes, there was fentanyl and methamphetamine in Mr. Floyd's system. Yes, he may have had, a pre-existing history of heart disease and hypertension. Fine, that does all need to be considered in when reaching the final verdict. But the carbon monoxide, or could have possibly been carbon monoxide, that's just a reach. I don't think anybody on the jury is buying that. But I guess that's what he was trying to do, was just sow a seed of doubt, because that's all they need, right? That's all they need is just some doubt. Maybe to win one juror over and get a hung jury. Now the interesting thing came in rebuttal. So the carbon monoxide levels in Mr. Floyd's blood were never introduced into evidence when the trial began. Or during discovery. And it seems that the state just thought that it was such a ridiculous notion. They never introduced that. So the former witness that the state called, Dr. Baker, called the attorney, Jerry Blackwell, or the other attorneys representing the state, and said that he, could get the carbon monoxide level test from Hennepin County, from the hospital where Mr. Floyd went when he died. Now, the problem there was that the evidence was introduced too late. You need to, introduce the evidence early. It needs to be, both the prosecution and the defense have to know what evidence is being used. So the judge did not allow them to use that evidence. Now, they wanted to bring back Dr. Tobin as an expert witness to rebuttal, saying that the carbon monoxide wouldn't have been possible. But the judge didn't allow it, and actually said that if he mentions carbon monoxide, it will be a mistrial. So they brought back Dr. Tobin, but he wasn't allowed to specifically say that it wasn't carbon monoxide that killed him, but he just talked about what the oxygenation levels in his blood were, 98%, which is normal. So that might have refuted that case a little bit. So what are my thoughts as we go into closing arguments and deliberation? Oh, we also have to talk about the fact that Chauvin himself did not take the stand. He used his Fifth Amendment right against self-incrimination and did not take the stand. The judge asked him if he'd been promised anything or threatened into not taking the stand. He agreed that it was his decision not to take the stand. So the interesting thing with that is here in the United States, you do have that right against self-incrimination. You don't have to testify in your own trial. You don't have to testify for or against yourself. But I think this is going to work two ways. So even though he doesn't want to testify, and that may look bad because it makes it look like you have something to hide, the reason for not testifying is because that would open him up to cross-examination from the state, which means they could ask him questions that would essentially trap him into an answer that would, incriminate him, which is why you have the right not to do that. However, it can also make it look like you have something to hide. But the jury isn't allowed to take that into consideration. They can't use that as a reason. Somebody refusing to testify is not a reason that they are guilty. Now, even though that's the instruction on paper, it does cast a negative impression in their heads. Because even though they can't state that as a reason for whatever, whether they find guilty or not guilty, it's still in their head, and they might be thinking, well, if he didn't have anything to hide, why wouldn't he want to testify? But, a lot of times the defense keeps the defendant from testifying because it can open them up to incriminating questions. So that's why they did that. So we've got closing arguments coming up on Monday. We have to see those. As it stands now, I'm starting to think he may be found guilty for manslaughter as well as the murder 3 charge, because for the murder 3, they have to prove that there was indifference to human life or reckless indifference to human life, which, again, like the EMT testimony may help prove their case. So you guys let me know in the comments below, has the state of Minnesota proven Chauvin's guilt beyond a reasonable doubt, or will he be acquitted? And if he is acquitted, what will be the ramifications? Anyway, I'll do another analysis once I've heard closing arguments and once the verdict is reached. All right, bye guys.